Good afternoon, everybody. My name is Usman Qureshi. I'm an attorney, estate planning attorney in Texas, North Texas to be precise. I've been in the practice of estate planning for the past 11 years now, and I practice in the area of estate planning, as I mentioned, and probate law. And my offices are in the Dallas-Fort Worth area, Austin area, as well as the Houston area. So I'm happy to meet you all virtually and talk about this important topic called estate planning and why it is important for everybody to have these documents prepared. So we're going to talk about a few important things, basic but important things, and then it will take maybe 20 to 25 minutes after I am done talking about this topic. We'll open it up for questions that you can ask. And I'll do my best to answer every one of them. So, without any further delay, I want to begin. Jump into talking about estate planning. Before I begin, though, I want to talk about two aspects, two disclaimers, if you will. The first one is that whatever I'm about to share with you is not legal advice. This is only for educational purposes. This is to just give you some sense of what estate planning is. It's not providing legal advice. The second point is that whatever I'm going to talk about is not exhaustive. This is not everything that there is to know about estate planning. Of course, we are limited on time, and so I'm going to try to cover as much as possible and important aspects of it, of the estate planning, as much as possible. So with these two reminders or disclaimers in mind, we shall begin. The way I have organized my presentation or my discussion with you is surrounding two main questions. And I'll try to answer these two questions and see if, and answering those two questions will help discuss the information and convey the message that I'm trying to convey. Question number one that I will try to answer is going to be, why should I? Why should I consider estate planning? What's the need for it? Why should I bother having a will prepared or a living trust prepared? And why should I even give it any thought or consideration? I'll answer that question in a minute. And the second question is, how should I? If once I understand the importance of estate planning, what can I do? What steps can I take? And how can I make sure that I have my estate planning completed, my will prepared, my trust prepared? So these are the two questions. Why should I do it? Which is a more basic question, why should I do it? And then for many of you who have joined, really don't need maybe that question answered because you're already here and you're interested in and learning about how to do it. So, but this will give you some information about why should anyone, if you have to talk to somebody. I have a lot of people who come to me, who have done estate planning with me. They come to me and ask me, we have a group of friends or we have family members, this topic came up in our discussion, and they asked us, what's the point of having these documents prepared? So maybe some of this information will help you answer those questions for them. So turning to the first question, why should I have written instructions in form of a will or a trust? Number one is that we want to avoid, so that you can avoid legal consequences of not having a will or a trust prepared or have some instructions prepared. And under the legal consequences, some of the consequences are the fact that the distribution of your wealth, the assets that you leave behind, the things that you have, uh, who decides who decides what goes where and who gets what. So if you do care about that the assets that you leave behind go to certain individuals, certain nominated individuals, and in many cases you want to avoid them going to a certain individual or a group of people. We all have family, and we all have instances where we want to prohibit somebody from receiving anything that we have. So if you want to have that control and that say in who gets your things, then you should write a will about it, and you should have some estate planning documents prepared, which will dictate, okay, upon my passing, all of my things go to this person or this particular individual. Second reason why you should have these documents prepared is probably more important than the first one, at least from my experience, is that if in a will document or an estate planning documents, you also get to talk about, for those who have kids, who takes care of the physical custody of your minor children. Minor children being under the age of 18. So if you have any concern, if you have any desire to dictate who takes care of your kids, which most of us do, naturally, who have kids. So if you want to have that ability, or that um, if you want to have that choice of deciding or determining who takes care of your children, then in that case you have to have some instructions written about it. Now, if you don't have instructions, if you don't have some documents, some guardianship provisions or something to let everybody know your preferences, your choices, then there are certain default things that will happen, meaning the court ultimately is the one that will decide and determine who the guardian should be, and not you. So it's a very important factor that people take into account when thinking about estate planning, and understanding why you should have these documents prepared is taking care of guardianship. Another reason why people should consider having their estate planning prepared is because of expense and hassle of not having it. So if you can think about it, if you don't have instructions for yourself, and if you haven't decided, or if you haven't determined what happens to your things, and somebody else has to figure that out for you, somebody else has to decide or determine what happens to your things, or who takes care of your kids, then that is going to require it's going to require cost. It's going to require an expense, and that's going to incur legal expenses. You would have to likely have to go to court to have these things be determined and decided for you, because you did not do that in your lifetime. So somebody else has to decide it for you, and which is state law. The state law, there is some guidelines as to how things should be. For example, a will or doctor or estate planning, and you pass away, or someone passes, rules that do apply, but they have to go through court. You have to go through a court procedure in order for those rules to be implemented. So having estate planning, having completed estate planning, can avoid the unnecessary expense and time consumption, and in many cases, if you don't have your instructions, you could have family quarrels. You could have family members having different opinions. I was the closest to this person, so I should be the one in charge, or I should be the one receiving the artifacts, or the personal belongings, or whatever assets. So there could be a lot of confusion and contest between and among the family members. So if you are writing your instructions, you're making clear everything black and white, that you want it done. You want things to be done in a certain way, so there are no questions or problems that come later on. So these are some of the things that I wanted to share with you as to why you should do it. Mainly the legal consequences of not having their instructions. You don't get to decide how your assets are distributed. You don't fully get to decide who should not receive from you, who should receive from you. You don't get to decide fully who should be the caretaker or the guardian of your children. Of course, after this is after the passing of both biological parents. You know, if one parent does pass away, the other biological parent does have the ability and the right to take over. But in the event that something happens to both of you, then this question becomes that, wait, well, how and who and where? So you want to answer those questions. And of course, the third point I mentioned is that you want to avoid unnecessary legal processes, legal expenses, and time to go through that process of determining all this. So for those reasons, I as a practitioner, I highly recommend that everybody have a will written, everybody have some estate planning documents written. I'm going to turn to the second question of the that I shared with you earlier, and that question was, how should I? What are the things that I should be thinking about or considering that will enable me or help me approach this very important topic? So what sort of things I should be thinking about? So I have a few items that I want to talk to you about. First and foremost is you want to think about selecting an executor, selecting a responsible person who is going to be in charge in case something happens to you. So that person is called an executor of the will. You want to carefully consider, you know, all options and all things when you select an executor. And we'll talk about that in just a minute. I want to just kind of talk about just briefly what are the things that you should be thinking about. So number one was you want to carefully consider all options for selecting an executor. You want to identify your heirs. You want to make sure that whoever the individuals you want the assets to go to, and in some cases the individuals you want to prohibit from receiving anything from you. So under Texas law, you can actually call out that I don't want John to get anything from me, or I don't want Sally to receive anything from me, or have no decision making or no ability to say anything in my regarding my affairs after I'm gone. So you want to identify those heirs and identify those individuals who you want to take from you, and also who you want to not take from you. You also want to think about and make a list of a list of assets that you have. What are you leaving behind? It's a good point for you to have I recommend to my clients that they should make a list of the assets just in general, because if you're not there, and let's say a couple or a single person, if they're not living, if they're not alive, then 9 out of 10 times, nobody else knows what you have. Nobody else knows what assets you have, where you have your bank accounts, right? I mean, you can think about it right now to yourself. How many people outside of yourself and perhaps your spouse knows what accounts, where you bank, what bank accounts you have, what type of retirement accounts you have, what property you own, and what life insurance you might have. These things will, so you should think about identifying them so that the people who are coming after you, they're not scrambling, they're not, playing a game to find these things, and they can easily have some sort of an idea of a list of, okay, these are the things that this person has, so I need to get these, or I need to get a hold of these items. So that's another item, identifying what assets you have. And then another point that you want to keep in mind is selecting a guardian. So just like I talked about an executor, somebody who is in charge of winding up your affairs or managing your affairs, legal affairs after the fact, you also want to make sure that you select a guardian. Like we talked about previously, that the will gives you the ability to select these individuals that you want that you want to select as the decision makers. So you want to think about that aspect as to, okay, who should my guardian be. Now I want to talk a little bit about specifically about this point that I just mentioned, selecting an executor and or guardian. So I want to talk a little bit about what kind of things you should be thinking about, what kind of qualities or criteria this person should have. And in general, of course, this is a very personal choice and personal preference, and everybody will have a different view on that. But there are, in general, some things that you should be thinking about. So, just as a definition, executor is a person who's responsible for making legal decisions or handling, managing your financial legal affairs, whereas the guardian is a person who is responsible for taking physical custody of minor children, and minor being the age under the age of 18. Some people do ask me this question: what is it? Is it 21 or is it 16? 18 is the number where somebody leaves minority and reaches the age of majority. Now, some of the things to think about. Either of these two individuals can be an heir. So you can have a family member who can be an executor. Some clients have asked me this question. Well, what if, does it have to be somebody in my family, or does it have to be somebody outside? Is there any conflict of interest that may arise if let's say I name my son as my executor, and there's not. This is a very routine practice for people to name close family members as the decision makers for them, because that's the people you trust the most. So it follows that you can certainly name them and make them your decision maker. So it can be an heir, meaning somebody who is receiving, inheriting from you, but it does not have to be. On the other hand, if you feel like your close family members either are not old enough, not mature enough, not suitable for whatever reason, they may not be close in physical proximity, so then you can have another person. It could be any individual, any adult person who you trust, and that could be your executor as well as your guardian of the minor children. Also, you have to keep in mind that the executor or a guardian, even though they are only administrators, they're not beneficiaries, they don't receive anything from the estate. They don't have any power to give anything to themselves, meaning they don't benefit from the estate unless they're also a beneficiary, unless they're also named as a close family member who's also named as a beneficiary in the document or in the will. So unless they are also an heir, they don't receive any financial consideration, except for the fact that there may be some compensation, some reasonable compensation that you can include for them. So if they're assuming the role of an executor or a role of a guardian, there might be some reasonable compensation, customary compensation that may be paid to them, and that you can mention in the will whether they should receive, or if you want to make it that they don't receive any compensation, you can have those instructions be placed. Of course, all these things goes to my earlier point, is that if you want any of these things, any of these preferences to be mentioned, to be followed, then you've got to write about it. You have to have a document. You have to have estate planning done so that all these details can be outlined. Finally, the last consideration, of course, there's many, but I'm just, again, talking about a few that that I have seen people ask me about is physical location. Like, I know, everybody is not all family members are not close to each other in physical location. Some of us have family members far away from our locality, and many of us even have family members outside of the country. People who are immigrants, they have family members in another country. So I get asked this question: how should I pick that person? And that's one of the considerations that I give people, that you should pick somebody who is local to the U.S., to the country, and not necessarily somebody who's living outside of the country. For various reasons, they may have difficulty or restrictions entering the United States. They may have problems either not getting a visa if they're outside of the country. They may have language barriers which may prevent them from speaking the local native language, and then just the time for them to, let's say they did not have the language barrier, and if they did not have an issue, but just the time it would take for them to come, right? It may take a week, or however long it takes for them to get here. So it's better to have somebody who is in the country, or at least in North America, so they can easily just get on the plane and get here and help you with whatever you have entrusted them with. So I recommend people. So it doesn't have to be somebody living next door. It doesn't have to be somebody that's in the same city. Of course, as I mentioned, we have family, we have trusted friends all over the place. So the preference is that you should give after, the preference that you've given for their trustworthiness and other things. So if there's a person who's closer to you in physical proximity, that would be preferred over the person who is far away from you, for the reasons I have described. Another thing. So this was the point I wanted to share with you about how you should go about. So you identified your executors, your guardians. You identified your assets, what assets you have, and in some cases even liabilities. So you want to make a general list of the types of debt you have, mortgage, credit card, and what have you. And you want to identify the assets. You want to identify your heirs to ensure that the right people are getting from you. And if anybody you want to exclude, you want to make sure that you include them as an exclusion in your documents. So that was the how you should approach a subject. What are the things you should be thinking about when you are considering having these documents prepared? I want to next talk about briefly this procedure called probate. And many of you may have already heard about it. Many of you may have even gone through it for a family member. So probate is a legal process, is a legal procedure that has to be completed after someone passes away. After someone passes away, they have a will that they leave behind, or if they don't have a will document or no instructions, they have to go through this legal process of probate in order to implement their wishes, their desires, and whatever their if they did have a will, then it has to be implemented through the probate court. And that's the basic definition. Court process to get your will and your will implemented and your legal affairs settled. Let's say if you had debt, if you had a mortgage, if you had credit card, if you had any of those things, through the court legal process called probate, the court then authorizes and enables another person, like the executor, to act on your behalf. And that's what probate is. And I'm sharing this with you because of what I'm going to talk about next. So I just described to you what probate process is. Now I'm going to tell you about what in recent last 5-7 years, people have really started asking me about a living trust. Many people have heard of the term, or if they have seen an article on it, or if they have, or may have a friend or family member who has a living trust. So it has piqued uh, people's interest. So living trust is a document, or is a way like a will, which allows you to do the same thing that the will does, which is to have your assets be distributed to the next generation. That's what the main purpose of the will is. A living trust does the same thing. However, it can do that more efficiently. It can do that more efficiently by avoiding probate. So the process I talked to you about just a minute ago, having to go through the court system in order to implement your will. If you have a living trust set up, if you have a living trust established in your lifetime, then you can do the same, you can achieve the same goals, which is distribute your estate, distribute your assets to the next generation, but you can also avoid the probate process. So many people who I come across and I explain these processes to them, and again, they have some memory, some distant memory or some recent memory of having to go through probate for somebody, like a family member, mother, father, uncle, aunt. So they tell me, well, I don't want to go through, I don't want my family members to go through probate. So then I recommend to them that, hey, consider setting up a living trust, and this will help with the avoidance of probate. So that's in a nutshell what a living trust is. It allows you to pass on your wealth to the next generation without having to go through probate. There are some other features of it too. I'll just mention one other feature, which is kind of unique, which is distribution in increments. So a trust, a living trust, or a trust in general, can give you some flexibility on how to distribute your wealth. Unlike a will, in which you say, okay, upon my demise, John gets X or Sally gets Y. In a trust, in a living trust, what you can do is you can have a little more flexibility. You can say, instead of John gets X, you can say John gets X at a certain point after they have attained the age of 25, and after they have completed some other milestone that you can leave, that you can stipulate. And you can also break that up. You can say John gets X at the age of 25, and John gets a second installment. Maybe John is supposed to get $100,000 total, but John can get that total inheritance broken up over a period of time. So at 25, John gets 50,000. At 27, he gets um, another 25,000. At age 30, he gets the remaining 25,000. So it gives you the ability and flexibility to do a little bit more than a will. So that's, again, people ask me what a will is and what a trust is, excuse me, and that's what I like to share with others. Is the main feature, the main thing about a trust is that it can avoid probate, and that's why most Texans like it. So because they don't want to go through probate, and they don't want their family members to go through probate. So living trust can avoid that process. I'm going to come to sort of a winding down of my talk, of my discussion, and I'm going to do that by just answering some of the commonly asked questions, and then I'll open up. I know there's folks out there who may want to ask me questions, and Carly has been kind enough, who will assist and facilitate in that process. So one of the questions that I get asked is the documents that I prepare in one state. So let's say you have a will or trust prepared in Texas. Is that valid if I move out of state and I go to another state? Say I move from Texas to Florida or New York or California. And the answer is yes. The document themselves are, if they're properly executed, made in one state, they are accepted by, let's say, you made the document here, but then you passed away somewhere else. So those documents that you prepared are going to be accepted and honored by other states. So documents made in one state are valid in other states in the country. Now the question is, if you do move, should you go back and revise a few things? And the answer is yes. It's always a good idea to, whenever you move, it's a good idea for you to contact a local attorney there, an estate attorney, and say, hey, look, I have this will made, I have this trust made. Can you please take a look and see if there's anything that needs to be revised? Maybe something needs to be tweaked, and that is a good idea. But as a whole, in general, the document is going to be valid and accepted. Other question that people ask me, can I modify it? Can I change what I say in a will or trust? And the answer is yes, in most cases, unless you have a particular type of trust, which is called an irrevocable trust, which is we're going to talk about later maybe. But you can modify your will and trust documents at any time. There's a procedure you have to follow. You just contact either attorney who has prepared the original documents for you, or if you move to another state, then you contact the local attorney there and seek help for amending or changing your documents. So these are some of the questions that I wanted to, and I know I've kind of gone over my time. I was thinking maybe 20, 25 minutes, but I'm at the 30-minute mark. So I want to open up for questions and see if I can answer some of the questions from the audience. So I'm ready to answer questions. I'm going to see if there are questions that are coming to me. All right, let me go to the comments tab. Okay, there, 1 second. Okay, in the comments section, all right, so I'm not going to ask, put any names out there. I'm just going to ask these questions anonymously. So one of the questions somebody asked is, I'll read out the scenario and the question, and then I'll answer it. My mother added me to her bank account to help her manage her finances. Is there any reason a joint bank account would be a bad idea if one of us passes away? So if the mother added you to the bank account, so legally, when you are added to the bank account, you become a legal owner of that bank account. So while it's okay for you to manage her finances by being added to the bank account, if something happens to you, then legally, technically, that 50% ownership of the bank account is yours. So someone could claim, let's say your heir could claim that, hey, 50% of that bank account should come to them, even though all the money in that bank account does belong to your mother. So it does open the door of somebody contesting that, hey, I should be getting some part of that money because your name was written on it and you are the half owner. What I would recommend in this case is that in many banks, you can be added as not necessarily as an account owner, but as an administrator or a signatory or some sort of a role that gives you the ability to manage the account, but not necessarily become the owner of the account. So I would say that you should look into that option to avoid this issue of getting into a situation where your heirs, if something happens to you and your mother is fine, or something happens to you and your mother, now we have this bank account with both of your names on it. How should we split the money? Should it 50% go to your heirs and 50% to mother's heir, even though all the money belongs to your mother? So you can avoid this dilemma by being added to the account as a signatory, or like an administrator, and that gives you no rights to the ownership. It doesn't give you any right to the money that is in the account. Second question asked, if you have a will, can that be converted to a living trust? The answer is no. A will is a separate document, and a living trust is a separate document. So a will cannot be necessarily converted into a trust, but you can have a trust be added as an addition to the will. So you can keep your will, and you can have a trust be added, because when you have a trust, you actually have to have both. You have a living trust document, and you also have a will document. So those both documents are prepared. So whenever I prepared a living trust document, I also prepare a will for them, because the will has its own distinct function, even with a will. For example, a living trust will do the distribution of the finances, while a will address the guardianship question: who takes care of the minor children? So you can't really convert it, and you should not convert it, a will, into a trust. You should add a living trust, and maybe modify a will in a way so it complements the trust. The next question that I'm being asked is, what is the cost of probating a will? And that's a good question. It really depends on what you are probating. So there are a few factors. First of all, where are you located? Like what state you're in, and what city you're in, which county you're in. So some of those costs vary based on the location, as well as what you're trying to probate. Now, do you have a complex estate that needs to be probated, or you have a simpler one? And the cost would vary. But in general, an approximate cost that I give to people can be between $2,000 and $3,500. And again, I know it's a big range, but there could be so many factors that play in to this that determine the cost. Did you have any real property? Did you have real property in more than one county? Did you only have non-real property assets? So it just depends on, did you actually have a will? I mean, in this question, yeah, it proposes that you have a will, but you can actually go through probate court even without a will. So the cost depends, and I just kind of give you a range on that. The other question that I'm asked is, what are the benefits to putting assets into a trust? And the benefits are, when you have a trust, it's not just a benefit, it's actually almost a requirement. You have to put the assets into a trust, and it's called trust funding, or funding the trust. Without that, if you don't fund your trust, if you don't put your assets into the trust or somehow link them to the trust, then the trust is not going to help you avoid probate. The assets that remain outside the trust will still have to go through probate. So whenever I help somebody set up a living trust, I make sure that I not only help them with setting up a trust or setting up their trust documents, but I also help them fund the trust, meaning putting the assets into the trust or linking the assets to the trust, so they don't run into the problem of having the trust but still going through probate, which is worse than not having a trust at all, because they went through the trouble and the cost and of everything of setting up a trust, but at the end of the day, they didn't fund it properly, so that trust doesn't really help them. The next question I'm asked is, can you have more than one executor? And the answer is yes, you can have more than one executor. You can have co-executors. You can have more than one person act as the executor at the same time, or you can have one after the other. John could be executor one, Sally could be executor two, and I just pick on John and Sally because that's the most common name that comes to mind. But yes, you can have more than one executor, either acting simultaneously, being co-executors or co-trustees of a trust, or you can have one after the other. The next question that I'm asked is, I've heard of something you can do with a bank account, or maybe it's a type of bank account that you can set it up to immediately distribute to the beneficiary upon death. So it's any type of account. So most type of accounts, so bank accounts, retirement accounts, and investment accounts, they have what's called a beneficiary. Beneficiaries can be named uh, in the account itself, so that if something happens to the account owner, those assets, the money, the funds in that account will go to that beneficiary, and it will avoid probate. So um, what the type of assets that will go through probate are going to be real estate assets and other assets that don't have beneficiary. And you may have, various types of assets, but the account assets, bank account asset that you have, which have beneficiary designation, they can avoid probate by having a beneficiary named. So you can avoid probate like that. However, I've seen instances where, let's say you have a husband and wife, and wife made the husband, or vice versa, and something happened to both of them. Now the account owner as well as the beneficiary is gone. Again, it's a kind of a unusual scenario, but it has happened, and I have seen it happen. So in that case, a trust can be really, really helpful, because what you can do is you can name in your account, in your bank account or retirement, you can name the trust as a beneficiary, as a backup beneficiary. So if something happens to, let's say, the husband and the wife, the trust will then be a backup beneficiary and secondary beneficiary, which will still catch the account and avoid it from going to probate. The next question I'm asked is, what's the disadvantage of using software to develop will? Um, so the disadvantage, I would say, is a will is a very important document that should require thought process, should require planning, right? Whereas a software online or something that you just fill out online is not going to help you. First of all, it's not going to think through the things that you would want to have thought about. Secondly, most people do this without any knowledge. So what you don't know, you don't know. You cannot expect a software to tell you what you should be thinking about, what are the pitfalls, what are the considerations you should be thinking about. So having a person and having a discussion with somebody, they will tell you, okay, hey, pick this person over this person, or do this one way, or don't do this another way. So it gives you that extra the ability and that feedback mechanism. Again, it's there's a lot of website out there where you can go in and fill out a form and do it, but you don't know what you don't know. You don't know what you have missed. You don't know what you have not considered. So using some sort of a DIY, an online system, has those restrictions and limitations. Is there the next question I'm asked? Is there an expensive service for creating will? My grandparents need to update their will created in the 70s, but don't feel they can afford a lawyer to create for them. I would be surprised that, I'm not surprised. You would be surprised that it does not take a lot of money. It doesn't take thousands of dollars to have a will prepared or a updated. Because think about it, everybody needs this. So the process and the procedure has been kind of made so that it is very simple. It's very easy to either create one or um, have one, amended. So the process is not very expensive to begin with. You don't have to spend thousands or even uh, several hundreds of dollars to have this service. Of course, I can't quote what it's going to cost, but there are inexpensive ways of getting your will updated or made. You just have to talk to somebody. Most people, most attorneys provide some sort of like an initial consultation where you can talk to them and say, hey, this is my situation. What is it going to cost? what is it going to take, and they're happy to share that. I share that information. I don't share that information just blindly without knowing what I need to do. So, but if you talk to me, if you come to me, I will definitely tell you what it would cost to either prepare one or amend one without actually doing the work, so you know what the cost is before the work begins. Another option is that there are many legal options, legal plans. Of course, Texas Legal is one of them. There are a lot of options and plans out there that you can use, that you can utilize and take advantage of, and they're fairly inexpensive. I think they're very affordable, where you can subscribe to those plans, and then through that plan you can have access to a lawyer who can help you with your documents and with your estate planning. The next question I'm asked is, does a will have to be notarized and filed at the county to be legal? So part of it is yes, and the other part of it is no. The document, in general, the will has to be notarized as well as witnessed, but it does not have to be filed anywhere to be local. So it has to be notarized and witnessed. However, there's an exception for a type of will called a holographic will. And that's a handwritten will. In Texas, a holographic will is accepted, which is basically you write your will in your own handwriting. I give this to this person and then signed by me, and that's it. That's a valid will. That does not have to be notarized. If it's in your handwriting, it does not have to be notarized. It has to be signed. However, I always caution against holographic wills because they can be very easily challenged. You can think about just various ways that there's no witness, there's nobody else that you wrote that will, there's no notarization. So they're very easy to challenge. Another thing is that people have very different and sometimes very creative handwritings. So if you do a document like that, sometimes good luck just making sense of what it says. So I don't recommend holographic wills. It's an option out there. Just to answer this question completely, I did mention that. But in general, yes, you do have to notarize them, have them witnessed, but they don't have to be filed anywhere at the county to be legal. Second, the next question I'm asked, how can I allow my spouse to use my assets, especially my half of the house, during his lifetime, but ensure those assets eventually pass to my other children from prior marriage? So you can put the house in a trust. This is a kind of a tricky question. You can put the house in a trust. So the question is, how can I allow the current spouse to use and live in the house during his life? As long as he's alive, he can live in the house. But after his passing, the house should go to the children from previous marriage. So you can set up, there are multiple ways of doing that. You can set up a trust and put the house in the trust and put the conditions in the trust that, hey, house remains in the trust as long as this person lives, and after this person passes away, this property then goes to these other beneficiaries. So there's one way of doing that. Like I mentioned earlier, trust gives you flexibility and options. Another way is you can have what's called a life estate. You can give a life estate. It's a legal interest into the property. It means that the person who is given the life estate can have possessory rights while they're alive, and after they're gone, then the remaining of the home, or the remaining interest in the home, the legal ownership of the home after their passing, can go to the named individuals. I don't like the life estate too much, because then you only want to give certain percent, like half, and it can be tricky to have there. Again, it's beyond the scope of this discussion. We can talk about it one-on-one, but I give preference to living trust because it's cleaner, easier, and gives you more flexibility than life estate. Another question I'm being asked is cost of living trust. So typically, again, I kind of shy away from talking about costs because I don't know what I'm setting up or how I'm setting up, and there are elements out there that, whether you have some sort of a legal insurance plan, and obviously the cost will be covered by the plan. But I will just give very general, basic range. They can cost setting up of a living trust can cost between $1,200 to $2,000, depending on what you want, how you want to set it up, uh, how how you want to fund it, what assets you're funding it with. So just a range between 1,200 and 2,000. The following question I'm asked is pros and cons of a living trust versus a revocable living trust. So living trust and revocable living trust are one and the same. Living trust is a living trust. I think what you may be asking is an irrevocable trust versus a revocable living trust. And the answer is that revocable living trust can be changed, it can be canceled, it can be amended at any time. Whereas a irrevocable living trust, when it's made, its terms cannot be changed. There are some tax benefits that you get from an irrevocable trust, but I will tell you that the tax benefits have to be like significantly a lot of tax benefit in order for you to consider an irrevocable trust. But a revocable living trust is the most commonly used trust because of its ability for you to be able to make changes to that trust. So next thing I'm asked, there are different types of deeds: transfer on death deed, ladybird deed, deed with enhanced life estate. We talked about life estate. Are these beneficial to have? Um, the question is yes, depending on what you are trying to accomplish, what you're trying to achieve with these deeds. They can be helpful. However, they're not commonly used. They're not popular instruments because each of them have uh, can cause problems. So some of these ones you mentioned, after they are so they require you to take another step after the fact. So if you have a deed prepared, if you have a transfer upon deed prepared for somebody, you have to basically, after the person who made the deed, when they die after they've passed, you have to file something else with the county in order for that to be applicable. So anywhere where you have to take another step, or somebody else has to take another step on your behalf, and they don't take it, then you've defeated the purpose of having that document prepared. Or let's say if they lose the document, or if they have some other issues. So in general, they could be beneficial. However, they're not recommended. It's easier and better to have a will prepared, simpler, than to look into those. Now, as a last resort, if you don't have any other option, if you don't have any other choices, then yeah, you can consider them. But I would consider many other things before I revert to the transfer on death deed and ladybird deed and the life a deed with enhanced life estate. Next question I'm asked is, can I stipulate that an heir pass a drug test or enter into and complete rehab? That is, you can do that. So the question is, can you stipulate in your document that the heir could, passes a drug test or completes rehab before they get their inheritance? Yes, you can certainly do that. But keep in mind that if that condition is not met, then you gotta have if and but, if and then, right? So if it doesn't happen, then do that. So yes, you can have that condition, but you also have to have then another avenue if that condition is not met. So if Johnny is not drug free, then the money goes to Sally. That's it, something like that. You can't just say, oh, if Johnny doesn't pass the drug test, he can't get it. Well, then okay, then who can? So we got to just address that those scenarios. The next question. Are there legal documents that should be prepared other than estate planning? And the answer is yes. Well, I mean, the estate planning is sort of comprehensive. Under the estate planning, you have not only just a will prepared or trust prepared. There are other documents that need to be prepared related to healthcare, related to medical decision making, legal decision making, like powers of attorney, advance directive. If you want to have a DNR prepared, like do not revive you in case some emergency happens. So there are other documents that should be prepared related to someone's health. And so yes, the answer is yes. There are other documents with estate planning, with the trust or will that are prepared. And I routinely prepare them. I usually almost never prepare just the trust and will documents. And I almost always prepare these additional documents with that. I believe I'm getting to a stopping point now. I am going to answer one last one. My grandmother passed away in April, and I was told since her state was less did not have to. So the question is, is there a way to avoid probate if the assets are less than a certain threshold? And the answer is yes. This is called a small estate exemption. Small estate exemption, which simply says that if your assets, excluding your primary home, it does not actually take into account your primary home. If your assets are less than $75,000, then you don't have to go through a full-blown probate. You can go through and have a small estate affidavit be prepared, and that can help you with that process. So anybody who's interested in learning more about that, and if their estate is modest, less than 75,000, and you got to make sure this includes all the bank accounts, retirement accounts, life insurance policy, everything that they had is less than 75,000, then they can look up or consider going through a small estate exemption. There's some forms that you have to file. Still, you have to file them with the court, but it's not the lengthier, full-blown probate process. I want to thank everybody for their questions and their comments that they put. I really appreciated them. I enjoyed having this discussion with you. I put my information out there. I think Carly, if I didn't get to everybody's question, and know some of these questions were specific, so if you have any follow-up questions, Carly can help you. Get to my website is out there. My information is out there. You can come talk to me, set up an appointment, and I can talk to you in detail about your particular subjects and your particular questions. I'm happy to do that. So with that said, thank you so much, everybody, for your time, and see you all on the other side.